Good evening, everybody. Thank you for joining this breakout session, which I will dedicate to Belgium employment, labor law or employment law. And what I would like to do is to guide you through this life cycle, I would say, from hiring to firing employees in Belgium. But I try to explain this based on a case study to make it a bit more concrete, or at least to explain you what I want to do is, and therefore I'm telling you a story of one of our clients, is that we have been contacted by, I will call it Easy Office, which is a UK company selling home office supplies. I do not need to explain that they are very active at the moment, they're very busy, and they also consider opening, or at least they want to expand on the European market. So the question comes up then, well, where will we set up our hub? And one of the considerations was to set up a hub in Belgium. So the next question is then, how will we staff that hub? And initially, they have examined that probably to do that, they would need 5 individuals that would need to be engaged in the Belgium hub. So they come to me and they ask me, what should we know in terms of Belgium labor laws before engaging those 5 individuals? So the question is then, what will I tell them, knowing that as here I only have half an hour or 14 minutes? So when addressing those questions, I have 4 types of things that I think are important for potential employers in Belgium when they intend to set up a company or to expand here. First of all, is to consider how to staff it, and then you need to know what are the types of staffing that are possible in Belgium. If you consider doing it by your own employees, then you should know what kind of employment contracts we can offer. Then also something about working time, because working time in Belgium is very complex, but very important. And then unfortunately, sometimes if things do not go well, you might need to terminate employment contracts. So it is perhaps important also that you know some things about that in advance, so that you know what are your potential risks if you engage an employee. But before going into that, so types of staffing. So you intend to set up a business here. The first question you might need to say is, how will I structure this relationship? Will I do this as an employee, or will I engage an independent contractor to do the job? Why do we have this distinction? Because, and that is something which is addressed in the other room, Belgium is quite expensive in terms of social security costs for as an employee, because you pay as an employer, you pay more or less, if it is a white collar employee, you pay 27% on top of the gross salary that you pay, and this is not capped. This is not the case if you work for independent contractors, because for independent contractors, the cost is social security, especially as of a certain amount that independent contractors will earn. There the costs are much lower, and this is also because social security contributions for independent contractors are capped. So might look very attractive to engage as somebody as an independent contractor, but as you can imagine, that is not without any risks. And the risk is fake self-employment, that both the authorities and the self-employed contractor can claim to requalify the relationship and then claim all sets of arrears. So it's important if you are considering this to really assess, is it feasible for me to structure the relationship as independent parties? And therefore, it is important to know the real distinction between a salaried employee and an independent contractor. And that is actually, and I think that's the case in every European country, it's all in the notion about authority and a link of subordination, in the sense that a self-employed worker works in a completely independent way. He decides what, when, and how he will work, and is actually committed to give you a product, to give you a result instead of time. So that is very important to consider this in advance. Is it feasible that I will work with that individual, but actually will not have any kind of control? Actually, if we then look at case law to see what the authorities, what the judges are taking into account to decide whether somebody, and that is will come up because of the authorities that are claiming arrears of social security contributions, or because of the individual themselves might start claiming employment rights. So what are then the criteria that will be examined to really make a decision whether this is a genuine contractor? Well, the law foresees 4 criteria that need to be examined. The first one is the will of the parties as expressed in the agreement. So it's important to have a good agreement in place with the various contractual clauses. Of course, they must also comply with reality. But very important is all in this notion of the freedom to organize the work and the freedom to organize the working time. In other words, a self-employed and independent contractor must be able to decide what, when, and how he works. So he must be able to decide whether or not he will accept some work, whether or not he will do it in the morning, in the afternoon, or even at night, whether he will take some holidays, etc., etc. So it's really all about this freedom to organize the work and his working time without any hierarchical control. Of course, there may be some general agreements that may be made in terms of what are the objectives that must be achieved, but an independent must deliver a result without any control in terms of how he gets to that result. What is neutral is whether we call this agreement independent or not, that will not make the difference. And also how we register ourselves towards Social Security, VAT, the way or we declare our taxes, that will be considered as neutral criteria. Judges will not take that into consideration to check whether or not somebody is really a genuine self-employed contractor. So that's a first option, if that is something you might consider, is how do the parties work together, and especially is it feasible? Because if it is not feasible to work in such an independent way, then the results might be quite expensive because of all the arrears that can be claimed by the authorities, but also by the individual himself. So you might consider this is too risky. I do not want this. I want some control. I need. I want to give instructions to my employee and etc. So you decide not to work with an independent contractor. We will do it in a employee relationship. But then the next question is, do I hire my employee myself, is become my own employee, or can I somehow outsource it? Because I have heard that there are some staffing companies who take up, or employers of records, etc. Is that feasible in Belgium? Well, the first thing I want to say there is be very, very careful. Because unlike in some other countries, we are quite strict on all those setups, because we have what is called a prohibited lease of personnel. So, and prohibited lease of personnel means that it isn't prohibited for a legal employer to put his employee at the disposal of a user company. And if that user company will start using the employee and exercise part of the authority over that employee. So which is exactly what an employer of record would do, which is, in other words, prohibited in Belgium. It is a prohibition. There are some penalties on it. There's a quite important criminal and administrative penalties on it, but also more importantly, there is a civil penalty, meaning that in case of prohibited lease of personnel, well, the employee is just deemed to be your employee and is deemed to have an employment contract with you. So it means that you become completely liable for everything. There are some exceptions to this lease of personnel, and actually that is what you will need to look at, whether you are considering to outsource it, whether it is feasible to structure the relationship under one of the exceptions. So what are the exceptions? There is an exception, but it is temporary for intra-group lease, but I assume this is between companies in the same group, subject to a whole set of conditions, but I assume that this is not applicable here. You might also consider to work via temporary agency work. What I would like to say here as well is be very careful, because a temporary agency needs a license in Belgium. So even if it would be a foreign temporary agency, they need a Belgium license, and it's a license from the region. But more importantly, you can only call on a temporary agency worker in a limited number of circumstances. So if you say, we want to engage a temporary agency worker in kind of a structural way, well, that may not be possible, because that is not foreseen in the law. So the last thing you can do then, it's organize it as subcontracting, to call on a contractor and a company that provides you as kind of the real outsourcing. But what is very important here in Belgium is that the service that must be provided must be a genuine service, and not consist in just giving an employee. Because if your service, of the service that the company is giving, is just the employee themselves, and then you start managing the employee, that will be considered as prohibited lease of personnel. So the only thing you can outsource are real genuine services, for example, management services, or really things, it's a product that they need to deliver, and not just the employees. Because if the service is just employees, then it is temporary agency work, and that is quite limited in Belgium as of when we can use this. If it is a service, then it's not sufficient. Another thing is that in the subcontracting agreement, there must be an instruction clause included, which will then list precisely which kinds of instructions, and there can only be operational instructions or in relation with health and safety, can be given by the client to the employees. So what I want to say here, be very careful if you outsource your staffing, because our legal framework is very strict and precise, much stricter than in some other countries. So if you then say, okay, this is all too complicated, I will engage in my own employees. Then the next question will then be, what kind of employment contracts can we offer to our employees, and what are there what is there the legal framework? What should we know about that? Actually, if we look at types of employment contracts, you can divide them in three big topics, I would say, which will differentiate the type of employment contract that you can give to a potential employee, based on the type of work you do, or based on the duration of your employment contract, and also based on the working regime that you, and we can do all combinations, but each topic has its own set of rules. So first of all, it's the distinction based on the type of work. And in Belgium, we still make the distinction between blue collar workers and white collar workers. There is the purpose is that we will come to the same set of rules that apply to both categories. This is not yet the case. The main difference is that in Belgium also we work based on joint committees, which is a sector committee, and in that sector committee we have collective bargaining agreements that apply for the sector. Well, blue collar and white collar in most sectors, they are part of different joint committees, meaning that the collective bargaining agreements are different. But if you have, I think for especially if you want to expand in terms of sales and etc., what is also important to know is that in Belgium, we have special rules that apply for sales representatives. And sales representatives are those people whose main job is really to prospect and visit clients in view of negotiating deals and sell and sign deals. What is important here is that unlike for the other employees, the other white collar employees, they are not subject to the working time rules. So that is the very good news. perhaps a bit more, I do not know whether it's the bad news, but there are very specific rules on commissions and variable pay that apply. So you have a bit less freedom to agree on bonus plans and commission plans. And also in case of termination, they might be entitled to an additional clientele indemnity. So that is a specific category with its whole set of rules. And then we also have, those category becomes more and more popular. We have the teleworkers, those working from home with the use of IT material. Well, there also we have specific rules that will apply for those employees. We will need to include in the contract some specific clauses that govern their situation. So that's the first distinction we make. The second distinction is based on the duration of the contract. We have indefinite for an unlimited duration employment contracts, and of course also fixed term employment contracts. What you should know that there is no legal obligation to have an indefinite employment contract in writing. If there is no employment contract in writing, then by law it is considered to be for an indefinite period of time, which makes that if you want to conclude a fixed term employment contract, it must mandatorily be in writing, and it must be concluded at the latest when the employee starts working. And signed by both parties. If that is not the case, by law, the contract will be for an indefinite period of time, meaning that instead of ending at the moment that you think the contract will expire, it will not be the case. It will be considered as for an indefinite period of time, meaning that the employee will be able to claim severance indemnity because you did not notify the notice period. So very important, fixed term contracts, make sure you sign them in time before the employee starts working, because otherwise your contract will not be valid. The question then comes up, can we conclude subsequent fixed term employment contract? Like say I have somebody for 4 months. After 4 months, well, the person works very well. Can I conclude another employment contract for 4 months, or is that not possible? But the basic rule is that in general, it is quite exceptional, because our normal system is that employment contracts should be for an indefinite period of time. But there are 3 exceptions to that. The first one, but you can actually forget it, but the first one is that if it is justified by the nature of the work or by the circumstances. But what we see in practice is that this concept is interpreted extremely restrictive. So most of the time it will not work. So you will need to work with one of the 2 other exceptions. And I would say the one in practice that is applied to most is exception number 2. And that's kind of a mathematical rule, because what exception number 2 says is that you can have subsequent fixed term employment contracts for a total maximum of 2 years, provided that each fixed term contract is at least concluded for 3 months, and provided that in that 2 years term, the number of fixed term contracts that you're concluding is maximum 4. So that is why I always call it the 2-3-4 rule. So you can have total maximum of 2 years, each contract minimum 3 months, maximum 4 contracts. So that is actually the most straightforward way to have a consecutive fixed term contracts. There is also another exception where you can go to a maximum of 3 years, provided that each contract is at least 6 months, but therefore you need the prior permission by the social inspectorate, which is also given not only in quite limited number of circumstances. So that is why the most frequently applied is number 2, so 2-3-4 rule. So that are the contracts, fixed term contracts. And then the last topic was based on differences in working regime. We have either full-time contracts, which in Belgium is on an annual basis, it's on an average 38 hours, but I will come back to that in a minute. But you can also conclude part-time contracts, and a part-time contract is a contract for less than a full-time working schedule. What you need to know here is that we have minimum limits, in a sense that part-time contract cannot be less for a duration less than 1/3 of the full-time working time that applies within your company. And also each period that an employee comes working must be at least 3 hours. So if you have, for example, a part-time employee, you cannot say, well, on Monday, the employee have to work 2 hours. That's not possible because each block must be at least 3 hours of work. Also for part-time employees, employment contract must be in writing and must be concluded at the latest when the employee starts working. Excuse me. You can have fixed working schedules, but also variable working schedules where we agree, well, actually we will work on an average, let's say 20 hours, but the way we will fill this 20 hours, that may vary from one week to another when you will have to work. Well, if that is the case, then those variable work schedules, you will need to have a framework setting out the general principles how it will work in your work rules, because that's something else in Belgium. Every company must mandatorily have work rules. It's like an employee handbook. And that employee handbook of those work rules, they contain some basic rules of how the parties will work within the company. And it is mandatory and it has to be sent to the social inspection. And it's important that you have it because in case of control by the social inspection, they will always ask for a copy of the work rules. What is also important is that if you have to introduce it by following an information and consultation procedure with the employee. So it's not just something you can do yourself and send to the social inspection. No, you have to also apply an information and consultation procedure. So that are in a nutshell what our possibilities are in terms of employment contracts. Another thing you might need to know in especially if you are considering or thinking where you will invest or where you will set up your company or your office is that we have strict language rules in Belgium depending on the region where the seat of the employer is located. And in Flanders, it means that everything must be in Dutch. In the Walloon region, everything must be in French. And in Brussels, it must be in Dutch or in French, depending on the employee's choice. But that is actually even more important is what are the consequences if we draft our documents in the wrong language? Well, I would certainly advise not to do it in Flanders or in Wallonia, because if documents, communication, and whatever are drafted in the wrong language, so not in Dutch or not in French, then the document is just deemed not to exist. So everything is null and void. So in other words, in Flanders and in Wallonia, we cannot use English documents. They will just not they will just be considered as non-existing. So you need to translate everything in the applicable language. In Brussels, that is not the case in a sense that in Brussels, it needs to be in principle in French or in Dutch, but the good news is the penalty. The penalty is not that if it is drafted in the wrong language, that the document itself does not exist. No, it is that the penalty is just that the employee can ask for a copy in or an original one in the appropriate language, but the contract or the document itself will still be valid. So that is the reason why in Brussels, if you're located in Brussels, employment contracts, etc., you can still go ahead with offering them in English. You should just know that if an employee asks to get it in the appropriate language, that then you have the obligation to give it in the appropriate language, but the contract itself will still be valid. Whereas in Flanders and in Wallonia, everything you put in there is just deemed not to exist. So you can even not rely on everything that has been put that has been put on paper. So especially in Flanders and in Wallonia, be extremely careful with the use of languages. And just that you know, Zaventem, which is around the Brussels airport, where there are a lot of companies, that is Flanders. So everything needs to be done in Flemish in Flanders and in Zaventem and so forth. Another thing which is important is that we have a hierarchy of sources of law. You see it over there. What it actually means is that on the top of my hierarchy, that are the provisions where parties cannot deviate from. You see that the written employment contract is somewhere in the middle. And what it means is that we cannot deviate on something which is provided on a higher level, but we can deviate on something which is provided on a lower level. So if we look at written employment contracts, we cannot deviate even if we agree to it in the contract. It will be null and void if it is not in line with what the law says or the CBA, so the collective bargaining agreements which apply at national level or which apply at the sector. But we can deviate from other things which are below what is provided here in this hierarchy of sources. So that is also something which you should also keep in mind. If you agree something in the contract, if it is against something which is provided in a sector CBA of your sector or which is provided by law, it will just not be valid. So it is just a piece of paper, but it will not be enforceable. So that was, in a nutshell, if you start, you decide, I will engage the person as an employee. We are negotiating our employment contracts. The next thing, which is also important in Belgium, is working time, because our working time rules are very complex. I try to summarize them on a one-pager, which is a simplified version. But what it comes down to is that the maximum working time we have is an average of 38 hours per week on an average on an annual basis. What does it mean? It means that you can have the choice is to either say we will work 38 hours per week, or you say effectively, or you say, no, we will work 40 hours per week. But if you work 40 hours per week, then employees should be granted 12 working time reduction days per year, which is actually 12 additional days off, so that on an average, on an annual basis, the employee is not working 40 hours, but 38 hours per week. And it is important that during that reference period at the end of the year, you come to an average of 38 hours per week. So those additional days, they come on top of your holidays. And in Belgium, holidays, employees are entitled, if they have worked a full year, to 20 legal holidays. So then plus 12 additional ones, if you have them work 40 hours, means already 32 days off. We have a prohibition to work at night, and night work starts at 8 p.m. and until 6 a.m. It is also not allowed to work on Sundays or public holidays. It's also prohibited, of course, and that also applies for the normal working time hours. There are some exceptions, but under strict conditions. For example, for shift work, etc., all those work patterns for the specific types of work which cannot be interrupted, where of course there are some exceptions provided. But then another thing is, what will happen if we work more than our foreseen working schedule of 38 hours on an average? Well, then the question comes up, is it overtime? And what happens if we have employees work overtime? The first thing that you need to know is that overtime is only allowed in a limited number of cases. So it's not like that you can say, well, they will work longer, I will just pay for it. No, legally speaking, you should have a legal ground for that. For example, if you're dealing with exceptional increase of work, and then in some cases, depending on the ground and the company, the size of the company, you might need to follow internal procedures also with trade unions, etc. But what is important is when overtime kicks in. Overtime kicks in when you work 40 hours per week, so more than 40 hours per week or more than 9 hours per day. So even if you have a work schedule of 38 hours per week effectively, there will only be overtime as of 40. So overtime is as of 40 and as of 9 hours per day. If you reach one of those overtime rules, then employees are entitled to both overtime pay, and overtime pay is an additional premium of 50% if the overtime is done during the week, and 100% if the overtime is done on a Sunday or a public holiday. But it does not stop there. It does not suffice to pay for overtime. The employee is also entitled to compensatory rest. So actually, the hours that an employee is working more, they get additional time off for that. And then also during that time off, they will be paid their normal salary. And in addition to that, they get an additional premium for the overtime that they have been working. That are the rules in a nutshell regarding working time. What is important is that there are people exempt from those rules. And that is actually what we would call people or the employees who are in a managerial role or who have a position of trust within the company, really your senior employees. Of these types of employees are defined by a role decree and should be interpreted in a restrictive way. So if you only have 5 employees, then you cannot say 4 of them are in a managerial role. It's really the top of the company that can be considered as being employees in a managerial role or a position of trust to whom those working time limits do not apply. The only thing is that also for people with a position of trust and managerial role, the prohibition to work on Sunday or public holidays, that still remains, but not the limits, the working time limits, and they can also work at night. So that are but the very basic principles regarding working time. The only thing I can add here, but I don't have the time to explain it, is that there are a lot of exceptions and specific other schemes that can be put in place to have a bit more flexibility, but everything comes with a whole set of conditions and that has to be complied with, and in some cases also procedures that have to be followed. And then I come to my last topic that I think if you want to invest in Belgium and you consider to hire employees, we all hope that things go very well. But of course, sometimes, unfortunately, that is not the case. And the parties need to end the relationship. So it might then also be useful to know in advance what are my possibilities, how if I engage an employee, what is the flexibility for me to get out of an employment contract. So there, as is always the case with any types of contracts, how can contracts end? Well, if it is fixed term, it will normally be just by the expiration of the term. Can also be by mutual agreement, because the parties just decide, well, it doesn't work, we will end it here. Belgium is quite flexible on this one. We don't need to pay anything if it is upon mutual consent. Parties can just say, well, let's keep it as it is and we leave. Or the other option is if it is a unilateral decision, and then we are talking about dismissals or resignations. And it can be either with providing a notice period or with giving a or paying an indemnity in lieu of notice. I will come back to that in a minute. We also have special rules in case it is for serious misconduct, and it is just with immediate effect with nothing, but that comes, as you can imagine, with a whole set of conditions and also procedure to be followed. And then we also have in Belgium, as in the UK, I think, the concept of constructive dismissal. But I think what I want to highlight here is the possibility for employers to end the contract unilaterally. And in Belgium, you have the option. As employer, you say either you give a notice, and that means that you inform your employee, but actually it does not work, we will end it here, and it will be terminated after a certain period of time, a notice period, which is determined by law. Or you say, well, actually, I do not want this. It has to stop immediately. So we are not, as in Belgium, we have not this obligation that you always have to serve a notice. So you can also end it immediately without any notice to be served. But in that case, the employee will be entitled to an indemnity in lieu of notice, which is basically his salary and benefits that he would have had in case he would have performed the applicable notice period. The difference between two schemes, so it's completely up to the employer to decide which one he will use. If the decision is made to give a notice, then there are some strict formalities that apply. And if those formalities are not complied with, then the contract is deemed to stop with immediate effect, and the employee will be able to claim an indemnity in lieu of notice, because to end a contract with an indemnity in lieu of notice, that is really without any kind of formalities that apply. If you decide to do it via notice, just know that there are strict formalities. It has to be done by registered mail. It will only be effective 3 working days later. The notice period can only start running on a Monday. So there is a whole set of rules that needs to be followed. But in both cases, it is always important to know how the notice periods work in Belgium, because either you have it performed, or if it is not performed, then it will be paid out. Well, in Belgium, we have new employment rules in this regard since 2014. And the notice is merely based on seniority. So it's really based, it's only based on seniority. So it's really based on how long the employee is in service. And it's quite mathematical. So it's, unfortunately, I cannot summarize it in one rule, because we see during the first 5 years, it is really a gradual increase of the notice period. And what is perhaps important to say is, in Belgium, we don't have this possibility to conclude a contract with a trial period. And we don't have this, a probation period or a trial period. That simply does not exist. And the reason for that is that during the first 6 months, our notice periods are extremely low and short. So that is why the legislator then came to the conclusion, well, since our notice periods are in any event so short, we don't need any trial periods anymore. After 5 years of seniority, then we can have a mathematical rule. Then you can keep in your mind, it's 3 weeks per started year of seniority. And then after 20 years of seniority, it goes down again. On the 20th year, it gives you 2 weeks additional notice. And as of more than 21 weeks, it gives the employee only, 21 years of seniority, it gives the employee only 1 additional week. And that is more or less the result of those 3 sets of rules together. So you see here that during the 5 first years, it goes up quite quickly in number of weeks, up to 5 years. It's each term, each quarter is changes, depending on the length of service that the employee is in service. And then we have it from 5 to 20 years, it's just an additional 3 weeks. And then between 20 and 21 years, it's 2 weeks that come on top of it. And then as of 21 years per each year, it only gives 1 additional week per year of seniority. So that is then exactly per each year what it gives in terms of notice, which is so only depending on seniority. But that are the rules in case it is the employer that gives the notice, so that dismisses the employee. What if the employee wants to resign himself? Well, there the basic line is for the employee, the notice is half of the notice period of the employer, but with a maximum of 13 weeks. So once we are at 13, it stops. So you can never have an employee or never ask an employee to work more, a notice period of more than 30 weeks, because 13 weeks is really the maximum. So if we translated then the same exercise as we have done for the employer, that is what it looks like based on the seniority of the employee. If the employee is resigning himself, what is the applicable notice period? It may sound all very complex and mathematical, but actually our firm has developed a tool which is free and which everybody can use. You just need to put in the data and then we will calculate it for you what the notice period is. You can even include all your salary data, and we will even say what the amount is in case you dismiss the employee with a severance indemnity in lieu of notice, and also what your employer cost is, because everything is subject in Belgium to social security. So you find it's in 3 languages. You find the link if you go to our website. You have the link there. You can just calculate it, and the tool will do it for you. Those rules regarding notice periods is in relation if we have contracts for an indefinite period of time. If we have a contract for a fixed term, then in principle, the contract ends when we come to the end of the term, which is logical. But then, of course, the question also comes up, what if we are unhappy? Can we terminate it before? And there you need to be quite careful because the general rule with fixed term contracts is that if you terminate it before the agreed period, then you need to pay until the end of the agreed period. But there is a cap on, being that what you need to pay can never be more than double of what you had to pay as a notice or as a severance indemnity in lieu of notice in case your contract would have been for an indefinite period of time. So there is a cap on, but it still remains that it is quite expensive if you terminate a fixed term contract before the agreed term. There is an exception to that, and that is when you would terminate the contract during the first half, but with a maximum of 6 months during. So if you have a contract for 2 years, for example, the fixed term, the first half is 1 year. Well, that will not work. It is capped at 6 months. And during that first 6 months period or half, whatever is the highest, it is still possible to end it according to the normal notice periods. And then you only need to pay the normal notice period, but that will only apply to the first contract. And for example, will not apply in case we execute subsequent employment contracts, because as of the second one, this possibility does no longer apply. And we come back to the general rule that it is in principle remuneration until the end, with this cap of 2 times what you would have paid in case the contract was for an indefinite duration. Then a last slide I want to highlight is in terms of termination. So Belgium is quite flexible in terms of procedures to terminate, but we might be a bit expensive if the contract is terminated without indemnity or without notice periods, because the indemnity in lieu of notice is calculated not based on the monthly, the base salary only, but based on all benefits. So you need to include that in your indemnity in lieu of notice. As I said already, so that is an example of a calculation of of an annual salary. So let's say that the notice period is 10 weeks. Well, and we want to end with immediate effect. What we will need to do is make a calculation of the annual salary of the employee on an annual basis based on the whole compensation package. Then we come to an annual amount. That amount we will need to deviate by 52. So we come to 1 week and then multiply by 10 to come to the relevant indemnity in lieu of notice in case we want the employee not to serve the notice period, but to terminate it with immediate effect. As I said, quite flexible in a sense that as an employer, you can decide to end the employment contract. We don't need any permission of any authorities. You don't need to follow any kind of, I'm talking here about individual dismissals. We don't need any prior information and consultation procedure. So you're really the master to terminate the employment contract. The only thing is that the employee might ask for the reasons for the dismissal. And if afterwards, so once it is done, and the employee must do that via register mail. If the employee does that, then the employee need to respond to that within 2 months, also via register mail, and then precise the reasons for the dismissal. And if the judge considers that the dismissal is unfair, then a judge may grant additional compensation for manifestly unfair dismissal. But the compensation is capped. It is not like in other countries where it can be very high. It is capped. It depends a bit on the degree of unfairness. Can be between 3 weeks or 17 weeks, but the 17 weeks is really in case it is really manifestly unreasonable. Can be higher, but then the employee really needs to prove that the actual losses are high or more than the maximum, but I have not yet seen that in practice. So that would be my very, very high level overview on the labor laws in Belgium and how it works, going from the start in terms of how will we structure the relationship, narrow it down a bit to if we work as employees, what are the key things you need to know up until the end. And if it does not work out, which unfortunately sometimes happens, what are then the possibilities? So that was, I do not know whether there are any questions.
Thank you, Sophie. If anyone has any questions, please ask. I mean, maybe just one of the things that I would mention, just because of the UK context, is on the first bit of this in terms of self-employed versus employee, what is much more prevalent in Belgium than the UK is especially employees who are paid higher levels tend to set up their own companies quite often and invoice through the company, i.e. a single sort of person company, something that in the UK would be classified as IR35 and get you into trouble. In Belgium is fairly standard for higher remunerated employees, which is can be interesting, I think, for the employer, because it takes some issues away there, and also for the employee.
Yeah. No, and that's the reason why I started my presentation with that, because that is the first question you will need to ask. How will we, how is the relationship? Is this, but is this with a more senior person? We can consider this, but you only need to be sure that you can work as an independent. What will not work is to treat that person as an employee in a subordinate relationship, but then not give him an employment contract. So that is why I say you have to look whether it is feasible, and it is correct that for more senior employees, if they are genuine self-employed, that this is not so, that is commonly applied.
Does anyone else have any questions on any elements of this, or anything you want to ask Sophie? I don't think so, which is good because we're getting at the up to time. I would say, of course, Sophie is available if any of you want to get in touch with her. I think the key point here is that you need expert advice on employment in Belgium if you're going to employ people, because obviously, as any jurisdiction, there are specific contractual laws and employment law that you need to abide by. And also there are issues with the cost of employing people in Belgium can be quite high as well in terms of employers' contributions and employee tax and social security. So it's good to have the right setup to also ensure that you can keep that to a level that is acceptable for everyone.